Thank you, everyone. I really appreciate to get rounds of applause before starting when you speak about data protection, because usually people get a tendency to get more and more pale when you talk about the legislation and its demands. That's a good start. And thanks for the organizer to invite me to speak, even though this was kind of a hard task to give an overview of everything that happened in the legal field when it comes to data protection in 20 minutes. As you all understand, it's not possible to go into depth with everything, but I try to fly over and give you my personal opinion on what's the most interesting development when it comes to case law, when it comes to guidelines, and also upcoming legislation and things going on the national level when it comes to the supervision and the data protection authorities' work and so on. But really brief and just heads up, and you can go and look up these cases and read more about it later. So I start with case law from the European Court of Justice. And if you know me, you know that I'm very interested in the Court of Justice and try to read everything, every case about data protection and copyright and freedom of speech and so on. And of course, this is the most important, one of the most important courts when it comes to developing data protection. This year, we have kind of not so many cases as previous years, but with some interesting cases. And we have, as you will see later, a lot of cases coming up, so many pending cases, and some of them expected to be delivered already tomorrow. So maybe then we can know a little bit more about the right to be forgotten, for example. The first case I want to mention is a case that I have been following with great interest because it concerns, for example, the ad tech industry, the tracking of users, visitors on websites. It's the Fashion ID case. It's a case from a German court asking, following up on the case law in the Wirtschaftsakademie Schleswig-Holstein, Facebook fan page case that we talked about last year, and also this Jehovah's Witness case from Finland. And it concerns the joint controllership when it comes to companies or organizations or agencies installing different types of sharing function. In this case was the Facebook like button on your website. And the court held that the company installing this function was joint controller together with Facebook for the collection and the sending of the personal data to Facebook, but not for the Facebook's processing with the data later on. So it kind of narrowed down this concept of joint controllership from the previous cases, or at least made clear that it doesn't apply to all following processing when it comes to sharing of data. But this is, of course, very important, not only for Facebook-like buttons, for, as I said, for every type of technology when you use tracking scripts or something like Google Analytics and other types of analytics and different types of technology for serving ads and so on. So basically, this leads up to the question on the legal ground for processing data in this case. The court doesn't go into that in detail because the national court didn't ask it in detail, but it says that if there should be a consent-based solution, then it's, of course, the provider of the website that must ask for consent. And also that company that must provide the information about the processing. And if it's based on the legitimate interest ground, then it's both the company that used this technology and Facebook in this case that must have a legitimate interest, so in order to process data in this specific situation. What you need to do is, of course, to get some knowledge on what kind of technology you have on your company's website or your government agency's website, because many, as we have talked about previous years, many companies does not have that kind of control right now, and you're still a joint controller for that processing of personal data. The next case is a case about a classic data protection issue, the relationship between data protection law and freedom of expression, freedom of speech. And in this case, it was a person uploading a video recorded in a police station where policemen were doing their work, and it was uploaded on YouTube. And the question was this a processing of personal data under the Data Protection Directive? Kind of easy question, and it was clear the court answered it yes. The hard question is, could this be under the exception for journalistic purpose? And the person that uploaded this was not a journalist by profession, but he argued that he did this in order to share information about mishandling of his case and so on. And the court discussed previous case law, the Satamedian case, for example, from the Grand Chamber a couple of years ago, and said that journalistic purpose must be given a wide interpretation. So it's not about journalists, it's about everyone who wants to share information, discuss hot topics and so on. To share public information, opinions, and ideas. And then the court discussed the balance between freedom of speech and data protection, and how to weigh these interests against each other. And it says that when it comes to applying this exception, there must be a strict necessity that you need to process this personal data for a freedom of speech purpose. Otherwise, you can't use this exception. So with these guidance, it left to the national court to decide if it was under this exception in the individual case. The third case, I only may mention very briefly, it's Deutsche Post. It's about national legislation and demands from a regulator in the taxation area in Germany. And it's about if there is an obligation to provide personal data on employees that are responsible for handling customs issues at the company. And the national regulation said that they must provide some personal data about these persons responsible for these customs handling. And the question was this regulation in accordance with the GDPR? And the court said yes in this case. It said that it was necessary to fulfill a legal obligation, and it was not going too far, and it was a specific need for that kind of information in this specific case. So it's a little bit a more clear answer to the question than we had in previous case law on demands that agency demands on to hand out information. For example, the Österreichische Rundfunk, the very first case from the Court of Justice concerning data protection law. It was kind of vague, but this is a more clear-cut case. A short, brief overview over pending cases, and as I said in the beginning, it's really a lot of interesting cases coming up in the future with profound implications for many areas of data protection law. Already, I think tomorrow we have these two cases when it comes to the right to be forgotten, following up on the Costecha case, Google Spain case. And the court is asked, for example, in this case, on what about if it's sensitive personal data? Is it handled in a different way than in the Google Spain case? and what about the territorial application on these delisting demands? Should they be delisted only in EU or for the whole world? Very short, the questions in these two cases. We have a question that I think we mentioned last year in the panel on ad tech, for example. It's the Planet 49 case concerning what is a valid consent under the e-privacy regulation when it comes to cookies. And the question was, for example, when you have pre-ticked boxes for consent, if that's a valid consent. And some other issues in that case. That's from the Grand Chamber, and probably a judgment coming up during this autumn. There is also another new case referred from Romania, also concerning the consent under GDPR, the conditions for valid consent. And that's, of course, as you know, a hot topic in many countries right now, what is a valid consent under GDPR and the increased demands under Article 7, for example. We have a case also coming up very soon on the obligation for a hosting provider to filter out certain kind of data. It's a case from Austria, and it's about Facebook's obligation to take down personal data, defamatory data in this case, and if they only should take down in a specific case, or if they can have an obligation to take down similar content and look for similar content. So that's a very interesting and also fundamental case when it comes to the relationship to freedom of speech, of course. We have a couple of cases concerning transfer to third countries. We probably come back to them also later on this conference. And it's about, as you know, the standard contract clauses and privacy shield, if they are valid. It's often called Schrems II case, so it's basically the same question, but in relation to other mechanisms for transferring to third countries. We have a couple of cases on data retention, following up on the Tele2-Watson case, for example, when it comes to data retention, also affecting Sweden very much. And these cases, for example, concerns the limits of EU law when it comes to security, or national security, and so on. Is it a demand for data retention still under EU law if it's concerns, if the reason for the retention is national security? That's it outside the scope of EU law. And also some other questions in these cases. There's a case from Romania on camera surveillance, and it's another case on freedom of expression also coming up. So that's a little bit of what to look out for when it comes to the new case law the next year and maybe the year after that too. You have also some new guidance from the European Data Protection Board, EDPB, the new Article 29, as you know, and they are continuing to deliver guidelines in a very high speed, and they use this consultation process. So they put out a draft guideline, and you can comment on them, and then they finalize them. And I don't have the time to go into everything, but let me just mention three guidelines that I think is interesting, and we will come back to some of them later today. The most recent, I think, guideline is on video. Is about video surveillance, and of course a hot topic for Sweden that has a specific law in this field. And it basically analyzes the relationship with video surveillance and GDPR and every different parts of GDPR and how to apply them when it comes to video surveillance. And of course, the hot topics on facial recognition and so on that we come back to later this afternoon. There is also a guideline on the processing of personal data under the contract exception when it comes to online services. And it basically, if you summarize it very brief, it says that the contract exception should be applied very restrictively in this field, and you cannot only put it into the contract that you should do some surveillance or something, or it must really be necessary for the providing of the service in the first place in order to use this exception for the processing of personal data in a contract in a specific case. So it's important to read for everyone who tried to base their processing on this contract exception. The third and last is about the territorial scope of the GDPR, Article 3, and it analyzes the establishment criteria and the other criteria for having a processing that takes place outside the union, coming in under the GDPR, for example. Very complicated question and a kind of complicated guideline to read, but if you deal with this kind of issues, you definitely find it helpful in some way. There are some ongoing work when it comes to EDPB, and you can find a work program on their website. There's a work program for 2019-2020. For example, principles on setting fines, data controller, data processor relationship, updating of the legitimate interest guideline from the Article 29, and a guideline on data protection by design and by default, and on connected vehicles, for example. So a lot coming up. Upcoming legislation, not so much to say. There is a possibility, as you know, to have legislation, data protection legislation beside the GDPR, specific fields. We have for a long time been waiting for the e-privacy regulation. We are still waiting, and the Finnish presidency of the EU right now is trying to move this forward, but everyone's starting to be kind of not expecting too much in this when it comes to this legislation. But of course, you know, this is about, for example, the question of cookies, on handling of traffic data, on sending unsolicited emails, and so on. This is a case. This is the legislation dealing with that kind of issues. My last 2 minutes is about what's going on the national level. And here, of course, there are a lot going on, so you can only mention some brief things, some things very brief. As you all know, the national supervision has started. Sweden, for example, has the first fine out for a small Swedish school using facial recognition system. But there are also some more high-profile controllers being investigated right now. Google, Spotify, Bonnier Magazine, though the Google case has been transferred to the Data Protection Authority in Ireland. And there is a plan for supervision based both on specific topics and specific areas that you can read also on the Datainspektionens website. If you have an international look when it comes to the supervisory authorities, you probably heard about this big CNIL, the French DPA fine against Google for data processing in relation to Android operating system. Basically, the DPA concluded that the consent was neither informed nor specific when it comes to behavioral targeting. But of course, this points at a very important question on how to inform about a complicated processing, because Google has used this kind of graduate approach, where giving some brief information first and then more in-depth information. But CNIL said that this was hard to get the full picture of it. So it's a complicated issue, and the all of these cases probably will be appealed, and we don't know how it end up in court in the end. We have some interesting development when it comes to the Bundeskartellamt, the competition authorities' action against Facebook in Germany, and we have also very high fines when it comes to data breaches, as you heard in UK, over 100 million euros for 2 breaches in the UK. So a lot going on, and some of this we will come back to during this interesting conference. But I stop there.